Thank you for viewing this video to learn more about domestic violence restraining orders. We are pleased to provide this video to you in several languages, including English, Spanish, Korean, and Vietnamese. You can get written information about restraining orders from courts, libraries, community agencies, and our website, or call the National Domestic Violence Hotline to speak with someone. This video shows many forms and brochures. All of them are available in English, Chinese, Korean, Spanish, and Vietnamese from the court clerk and on our website, but you don't need them with you to watch this video. If you need help understanding the restraining order process or how to complete the forms, many community agencies can provide assistance. They can help you decide whether a restraining order is right for you. They can also help you with the forms to apply for or respond to a restraining order. Call the National Domestic Violence Hotline at 1-800-799-7233 for a referral to an agency near you.
My name is Ronald M. George. I am Chief Justice of California. The state of California is taking strong measures to oppose all forms of domestic violence. Our courts can and do issue orders to deal with this matter. If you have been named as the respondent in an action seeking a restraining order, you will be able to appear in court to give your side of the story soon. In the meantime, you are fully responsible for obeying whatever order the court has already issued in this action. This video describes how restraining orders are designed to protect people from domestic violence. You will also learn what your options are. I urge you to use the information in this video to make whatever decisions you feel are in your own best interests.
This video is about what to do when you find that you've been served with a temporary restraining order. We'll tell you the steps you must take and some of the additional things you can do to help make a difficult situation better. Although we've tried to use plain English to explain this information, there is a lot of detail and information to absorb, so please pay close attention. After you view this video, you will be in a better position to decide what else, in addition to obeying all orders issued by the court, you might wish to do. Throughout this video, you'll be hearing from several experts. Their role is to help you learn about what restraining orders are, learn the reasons they're granted, find out how restraining orders are obtained and how you can respond, learn the least stressful way to comply with a restraining order, learn more about domestic violence and what you can do about it. All of the experts portrayed in this video have special knowledge and experience in domestic violence counseling, legal assistance, personal protection orders, and court proceedings. With their guidance, you should walk away with a clearer understanding of domestic violence and the steps you can take to act in your own best interest. At the end of this video, I'll go over some of this information again and list specific places to go and the kinds of professionals you can consult for help. Let's begin by taking a look at some of the legal basics about restraining orders to help you better understand what is going on and why.
Each of us probably has a sense of what domestic violence is and whom it affects. The California Family Code Section 6211 describes domestic violence as abuse directed toward a spouse or former spouse, a cohabitant or former cohabitant, a person with whom there is or has been a dating or engagement relationship, a person with whom there are children in common, or any other person related by blood or marriage within the second degree, that is, a brother or sister or grandparent or grandchild. Under the laws that apply to restraining orders, abuse is basically any actual or threatened physical or sexual violence that is intended to cause injury, that actually causes injury, or that puts a person in reasonable fear of a serious bodily injury. In addition to physically striking a person, specific instances of abuse may also include threats to hurt or kill a person or the person's children, friends, relatives, or pets, throwing things at the person, pushing or shoving the person or pulling their hair, destroying the person's property, or using a weapon to hurt or scare the person. Often, people who believe themselves to be victims of domestic violence choose to get help from the court by applying for a restraining order. This process often has two parts: an emergency protective order that lasts a few days, and a restraining order that can last up to 3 years. In most cases, the judge will give a petitioner immediate protection within a day, then schedule what is called an order to show cause hearing for a later time and place. The emergency temporary restraining order is set out in a document called Order to Show Cause and Temporary Restraining Order. This is the document that is served to you, the respondent. If you are watching this video, you may have been served with this document. The Order to Show Cause and Temporary Restraining Order tells you the date, time, and place where the court will conduct a hearing to decide whether a longer-term restraining order should be issued. By taking certain steps and showing up at that hearing as scheduled, you will have the opportunity to protect your legal interests. Until the hearing, there's only one thing you must do: obey the temporary restraining order to the letter. You will be doing yourself a big favor by carefully reading the order and following everything it says exactly as stated until your day in court. Okay, if you have no children in common with the petitioner, the order will probably have you stop all contact between you and the petitioner and his or her household. This means no telephone calls, emails, faxes, or personal contacts. The order may also require you to remain a certain distance away from the petitioner while in public. If you do have children or you share an automobile, deposit account, and/or home with the petitioner, the order may also order you to immediately give sole possession of the residence to the petitioner, move out of the home, give custody of the children to the petitioner, stop all contacts with your children. These emergency measures may seem harsh, but they are only intended to provide the petitioner and his or her household with a sense of security pending the court hearing. Because you may be terribly inconvenienced by some aspects of the emergency order, the hearing will typically be held within 21 days after you are served with the Order to Show Cause and Temporary Restraining Order. Your ability to come through this process in a way that will benefit you as well as everyone else depends on your willingness to comply fully with the Emergency Temporary Restraining Order. Always keep in mind that soon you will have an opportunity to respond in court to the allegations against you and to the proposed orders. One more thing about emergency orders. If the police were called because of a violent episode in which you were involved, it is possible that the police obtained and served you with an emergency protection order. The purpose of that order is to protect the petitioner right then until he or she can arrange for a court hearing. As with a temporary restraining order, you should obey all of the instructions contained in the emergency protection order.
So, those are some of the legal basics of a restraining order. To summarize, when you receive a temporary restraining order issued by the court or an emergency protection order issued by the police, you must obey all of the instructions in the order. A court hearing will most likely be held within 7 to 10 days after you are served with an Order to Show Cause and Temporary Restraining Order. It's important that you obey all of the instructions contained in the court order during this period. To protect your legal interests, you must show up at the court hearing on the scheduled date and time. Now that you understand the need to comply with any emergency order, it's time to step back and review what types of orders the petitioner may be asking the court to issue after hearing the case.
There are many different types of restraining order requests. It is very important that you clearly understand the orders you have been served and what is being expected of you. To know exactly what the petitioner is asking for, you will first want to carefully read the application for temporary restraining order and declaration that was served on you at the same time as the Order to Show Cause. It is this document that sets out the facts that the petitioner believes justify the types of orders being requested. As a general rule, restraining orders apply when there is a close relationship between the parties and when there has been at least one act of physical violence or threat of physical violence. As with the emergency restraining orders set out as part of the order to show cause, restraining orders issued after a hearing can cover a wider range of protections, including custody, visitation, and child support. It can also cover personal property rights, such as use of cars, bank accounts or other assets, reimbursement for violence-related expenses, such as medical bills, changing locks, or repairing property damage, and paying debts. Now, let's take a look at some of the different types of orders a petitioner can ask a court to issue after a hearing. This chart shows the type of order on the left side and examples of basic facts that will justify the longer-term order on the right. A restraining order may be issued if there have been violent incidents, threats, or physical damage to property. A child custody order may be issued depending on the age of the children. A child support order will be issued if requested, as the state child support guidelines require. The use of automobile order is used when the family vehicle is needed for the children or the petitioner, and the respondent has his or her own transportation. A guns given to police order will be issued if the respondent has used guns to threaten the petitioner. The medical insurance for children order is issued when medical insurance is more easily available to the respondent than the petitioner. And finally, the respondent pay bills order is issued to ensure that the respondent pays for doctors and repairs to damaged property. Now, let's talk about some additional paperwork that you may deal with. If in your case the petitioner said that child support was needed, you also should have been served with a completed declaration of income and expense. This document sets out how much income the petitioner estimates you have available to pay child support. You should also have received a blank declaration form for you to fill out if you wish to contest the recommended child support. And you can get help with this form from your court's family law facilitator. Finally, you should have been served with a blank copy of a document called the Responsive Declaration to Order to Show Cause. This is an important one. It is the form that you will use to set out your legal position in the hearing. The Responsive Declaration to Order to Show Cause document requires very little of you. It simply lists the different types of orders that the petitioner may be requesting and asks whether you consent, meaning agree, to them. It also allows you to tell your side of the story, especially if you contest, meaning disagree with, the information the petitioner has supplied.
While you are making your decision on whether to oppose the request for restraining orders, make a careful note of all the restrictions that have been proposed. For example, you should read the firearm restrictions on the temporary restraining order form. If these restrictions are imposed, they will apply to you for the duration of the order.
If you answer that you do consent, the judge will know that it's okay to enter that order. If you indicate that you don't consent, the judge will know to look into the matter further at the court hearing.
If you are going to oppose any of the orders that the petitioner requests, you should carefully go over the events as stated in the petition and give your side of the story everywhere you disagree. If there are witnesses, attach declarations, and if there are documents, attach copies. It is important that your responsive declaration be complete because the judge may make a decision based only on what each of you have written. This is because there often isn't much time to argue every issue at the court hearing.
Once you complete the responsive declaration and the income and expense form if child support is an issue, you should do your best to have a copy of it delivered to the petitioner before the hearing. If you don't, the petitioner may ask the court to postpone the hearing. Ask someone else to deliver the response to the petitioner. Under no circumstances should you deliver the response yourself or create a situation that might be interpreted as violating the order contained in the order to show cause.
Check with the court clerk or see if the papers tell you the deadline for filing your responsive declaration. Ordinarily, it will be several court days before the scheduled hearing date.
In dealing with all these legal forms and documents, remember, you are not alone. You should get help when you need it. While you can go to court on your own, consider asking for assistance from a private lawyer, legal aid clinic, domestic violence support person, paralegal, family law facilitator, victim witness program, or other professional.
Let's take a moment to recap the legal forms and paperwork you'll need to deal with as a respondent in a restraining order action. First of all, read the application for temporary restraining order and declaration carefully. It gives you the petitioner's description of the facts justifying the type of orders requested. If child support is involved, you'll generally receive an income and expense declaration form telling you how much the petitioner earns and that you earn. To contest this estimated child support amount, you need to fill out an income and expense declaration for yourself. Finally, you need to complete the responsive declaration to order to show cause form to let the judge know that you consent, or not, to the types of orders that the petitioner is requesting. Once you've filed your responsive declaration and, if necessary, a completed income and expense form, your next step will be to prepare for the hearing. Let's first hear from two family law judges for their insights about court hearings on petitions for temporary restraining orders.
I set aside an entire morning each week to hear temporary restraining order cases. Unfortunately, we are unable to hear each of these cases at length. This is true throughout the state. As a result, I have to rely heavily on what I read on the forms the parties file. My job is to be sure that the court's rules are followed, that everyone is heard, and that I carefully consider the issues presented and make a decision that reasonably protects the parties from future violence. If there are children, I try to find ways to protect the child's well-being and safety while continuing a relationship with each parent.
My experience is much the same as Judge Marciano's. Although the time we have in court to hear these matters is short, there are a number of things that you can do to help us make a decision that meets your needs. First, fill out and serve each form properly. This means answering each question on the form clearly and completely. If possible, have a person over 18 who is not involved in the case give a copy of the forms you file with the court to the petitioner before your court date. This person should then fill in a proof of service form that you bring with you to the hearing to show me that the petitioner has had some advance opportunity to understand your position. If there is no proof of service and the petitioner asks for a continuance on the grounds that he or she did not get your responsive declaration, I may postpone the hearing for several hours or several weeks, depending on the situation.
Family law judges typically work hard to keep our courtrooms and procedures as informal as possible. You will, however, still be expected to wait quietly until your case is heard and to come forward and sit at the tables the bailiff shows you when your case is called. The exact rules for each court, though, will be somewhat different around the state. I ask whether both parties are present and ask both to come forward. If the responsive declaration doesn't contest any of the requests in the petition, I still may ask whether the respondent wants to contest or fight any part of the requested order. If the respondent says no, I most often will make my decision right then on the basis of the papers I have in front of me. If, however, the respondent indicates that he or she does wish to contest some aspect of the requested order, either orally or in the responsive declaration, I will dig a little deeper into the case.
In many cases, the only evidence I hear about domestic violence comes from what the parties tell the court. In this instance, I will listen carefully to both parties and make a decision that I believe is appropriate to protect both parties. If there are other issues in the case, such as child custody, visitation, child support, or a request to have the respondent move out of a joint residence, you'll probably be sent to Family Court Services for mediation. There you will meet with a trained professional who can help discuss these issues with you in more detail. Then you can return to court for a more permanent order. If a kick-out order is under consideration, then I will spend time exploring what alternatives are available for living arrangements to ensure that both parties are protected and have a place to live.
If the judge does issue a restraining order, the petitioner must then complete and submit a form called Restraining Order After Hearing for the judge to sign. The petitioner must then serve a signed copy of the form on you. At this point, there is a longer-term order, often 3 years, that can be enforced against you. Once the restraining order is obtained, the petitioner can file copies of the order with your local police or sheriff's department, carry a copy on their person, and give copies to your child's school, daycare provider, relatives, or others. Any police officer or sheriff's deputy can enforce or make you follow the restraining order.
It is important to keep in mind that once issued, the restraining order will typically last for 3 years. The date of the expiration will appear on the order. To keep the order in effect after that, the petitioner will have to schedule a hearing before the expiration date, which is usually 3 years later, to explain why the order should remain in effect. At that hearing, you will be able to explain why you believe there is no longer any need for the order. If in 3 years the petitioner does not attend the hearing, the order will automatically expire, and the protections it's provided, except for custody, visitation, and child support, will no longer be available.
Sometimes people find that the restraining order is too difficult to live with, or that they do not want it anymore. For example, you and the petitioner might want to try to get back together, or exchanging the children for visits becomes difficult, or there is some other problem with the order. If this happens, you and the petitioner can go back to court to get the order changed or dropped as appropriate.
The bottom line is restraining orders are direct orders from the court for you to behave in a certain way. This means that it is your job to obey the order in all respects. This also means that only you, the respondent, can violate the order.
Now you know what to expect at your court hearing and how to make the best of your time in court. Here's a quick review of what you're going to need to do. Fill out and serve your legal paperwork properly. Be sure to give a copy of the forms you file with the court to the petitioner before the court date. Attend all court hearings. If a restraining order is issued, you will be served with the restraining order after hearing form. You must obey the order in all respects. Before we close, we'd like you to hear from one more expert, a domestic violence counselor who works with both men and women.
You're probably wondering what your partner, as the petitioner, has been told. Well, to find out exactly what your partner has been taught about restraining orders, you should watch the petitioner video that accompanied this video. You may also, at this point, be feeling as though you want to contact your partner. It's important for you now to remember that your partner filed for a restraining order against you in order to be safe. This order means protection not only for your partner, but for your children and family members as well. When there's a restraining order, there are a number of legal actions and decisions to be made. Your partner and all of us would like you to think about what is in your best interest and to respect the instructions in the restraining order.
Thank you for taking the time to view this video. We hope it's given you the information you need to respond to restraining orders effectively. Consider getting help from a private lawyer, legal aid clinic, domestic violence support person, family law facilitator, paralegal, victim witness program, or other professional. And again, your partner and all of us would like you to think about what is in your best interest and to respect the instructions in the restraining order. Thank you.